A brick shatters a living room window in the dead of night. A woman named Christina climbs through the broken frame. She intends to steal the silver on the dining table. But before she can bag it, the homeowner walks in. In a panic, Christina strikes him with the brick, causing severe injury, and flees into the dark. The general public looks at this sequence of events and calls it a break-in. A law student evaluating this for an exam must dissect this single chaotic event into distinct, overlapping statutory liabilities. To execute that analysis, we have to systematically deconstruct Section 9 and Section 10 of the Theft Act 1968. This statute forms the architecture of burglary in English law, and mastering it requires precision. We will isolate the common Actus Reus, map the critical temporal divide between the two subsections of Section 9, and apply the appellate case law that defines exactly how these rules operate in practice. Proving burglary relies very little on demonstrating physical destruction. Securing a conviction depends entirely on tracking the exact moment a defendant's mental state crosses a specific legal threshold. Liability under both subsections of Section 9 shares an identical foundation. Prosecutors must prove the defendant entered a building or part of a building as a trespasser. The definition of entry has been stretched by the courts. In the 1996 case of R.V. Ryan, the defendant was trapped with only his head and right arm inside a window. The Court of Appeal ruled that this partial penetration constituted an effective entry. The fact that he was physically incapable of actually stealing anything in that position offered no defense. This diagram outlines the statutory definition. The law requires a building to possess permanence. Houses and factories qualify, regardless of occupancy. Section 9, subsection 4 expands this to inhabited vehicles and vessels, like houseboats, but explicitly excludes temporary structures, like tents. The statute also covers entering part of a building. In R.V. Walkington, a shopper walked behind a three-sided counter to access a till. The court ruled that crossing that physical demarcation meant entering a restricted zone without permission, satisfying the Actus Reus. For the purposes of the Theft Act, architectural structures matter less than invisible boundaries of implied permission and physical demarcation. Crossing a boundary is only half the equation. The defendant must be a trespasser in fact. This requires both the Actus Reus of entering without consent and the mens rea of knowing or being reckless as to the fact that they lack permission. A person explicitly invited inside can still meet this threshold. The landmark 1976 case of R.V. Jones and Smith provides the framework. Smith had general permission to enter his father's house, but on one occasion he entered with the intention to steal 2 television sets. The Court of Appeal established that entering a property with an unlawful purpose exceeding the general permission granted automatically renders the entrant a trespasser. When analyzing an exam scenario where a defendant uses an instrument to gain access, carefully observe the instrument's exact function. An instrument used strictly to force a lock does not constitute an entry, but an instrument used to reach inside and commit an offense is treated as an extension of the defendant's own body. This table summarizes the distinction. If a defendant named Majid inserts a wire hanger through a letterbox to hook a set of keys hanging inside, he has made an effective entry. Trespass is driven by the violation of the specific terms of an occupier's consent, not the mere mechanical act of bypassing a lock. This flowchart illustrates Section 9. Liability bifurcates based on exactly when criminal intent is formed. The left path reveals subsection 1A, burglary with intent. The state of mind must exist at the precise moment the defendant crosses the threshold. The defendant must intend to commit one specific offense inside: theft, GBH, or criminal damage. They do not need to actually execute the offense. The intention upon entry completes the crime. This includes conditional intent. In the Attorney General's reference numbers 1 and 2 of 1979, the defendants entered looking for money. The court ruled that intending to steal only if there is something worth taking perfectly satisfies the mens rea for subsection 1A. The right path reveals subsection 1B, burglary via commission. The defendant forms intent after entering. Crucially, the actually commit box excludes criminal damage. Under 1B, only committing or attempting theft or grievous bodily harm triggers this charge. Subsection 1A penalizes the dangerous plan the moment a threshold is breached. Subsection 1B penalizes the dangerous actions taken once the defendant is inside a vulnerable space. When a defendant introduces weapons into these vulnerable spaces, liability escalates to Section 10 of the Theft Act, Aggravated Burglary. This is an indictable-only offense, with a maximum sentence of life imprisonment. The statute provides a strict, specific list of aggravating items: firearms, explosives, imitation firearms, which includes harmless toys, and weapons of offense. A weapon of offense is broadly defined as any article made, adapted, or intended by the person to cause injury or incapacitate. In R.V. Kelly, a burglar used a screwdriver to assault an occupant who surprised him. Because he deployed the tool to inflict injury in the heat of the moment, the court ruled he possessed intent to use it as a weapon, securing the aggravated charge. This timeline illustrates the strict temporal requirement of Section 10. The defendant must possess the weapon at the time of the burglary. For a 1A charge, they must have the weapon right at the threshold of entry. For a 1B charge, they must have it precisely when they commit the ulterior offense inside. In the case of Francis, defendants who discarded sticks just before stealing defeated the aggravated charge. In O'Leary, a defendant entered unarmed, picked up a kitchen knife, and then committed theft. Because he definitively possessed the knife at the moment of the 1B theft, his conviction for aggravated burglary was upheld. You must precisely map the exact geographic location of the weapon against the exact second the primary burglary crystallizes. Let's apply this framework to the sequence we analyzed at the start: Christina, the broken window, the silver, and the assault. This summary table breaks down the elements. Christina smashes a window and climbs into a residential home without permission. Applying the Ryan precedent, she has made an effective entry and satisfies the Actus Reus of a trespasser. Because she climbed through the window specifically to take the silver, she possessed the intent to steal at the precise moment of entry. This immediately secures a basic Section 9(1)A burglary charge. Note the exam trap: smashing the window does not qualify under 1A. The destruction happened prior to entry, making it a separate simple criminal damage charge. Moving to the right side of the table, once inside, she places the silver in her bag. She has dishonestly appropriated property belonging to another with the intent to permanently deprive them of it while trespassing. This action triggers a parallel Section 9(1)B burglary charge for the theft. Her final action is striking David with the brick. She inflicted grievous bodily harm. Assuming she possessed the necessary mens rea for at least a Section 20 assault, this specific action triggers a second, entirely distinct Section 9(1)B burglary charge. Finally, the escalation. If the prosecution proves Christina carried the brick into the house intending to use it to incapacitate an occupant, the brick becomes a weapon of offense. She would be liable for Section 10 aggravated burglary from the exact moment she crossed the threshold. Flawless answers in criminal law do not rely on a general sense of wrongdoing. They are built by tracking the exact moment intent forms and locating precisely where the defendant is standing when the law is broken.